Section 19 Bravo. Individual accountability. 19.9. Enforcing standards. Enforcing military standards begins with individual accountability. There are some activities and behaviors that, while arguably not illegal, are nevertheless inconsistent with maintaining good order and discipline. Understanding the restrictions and our responsibilities for adhering to USAF standards will help prevent the need to reinforce these standards. The Air Force Complaints Resolution Program. The Air Force Complaints Resolution Program is a leadership tool that indicates where command involvement is needed to correct systematic, programmatic, or procedural weaknesses. Resolving the underlying cause of a complaint may prevent more severe symptoms or costly consequences, such as reduced performance, accidents, poor quality work, or poor morale. The program also ensures the effective and efficient use of resources, resolves problems affecting the Air Force mission promptly and objectively, creates an atmosphere of trust in which issues can be objectively and fully resolved without retaliation or fear of reprisal, and assists commanders in instilling confidence in Air Force leadership. Even though allegations may not be substantiated, the evidence or investigation findings may reveal systematic morale or other problems impeding efficiency and mission effectiveness. Submitting complaints. Under the Air Force Complaints Resolution Program, a member has the right to present a complaint without fear of reprisal and codified in Department of Defense and Air Force guidance directives and instructions. Complaints may be submitted in person, by phone, through electronic means, or in writing to supervisors, first sergeants, commanders, members of any level of the IG system, someone higher in the chain of command, or members of Congress. While members should attempt to resolve complaints at the lowest possible level before addressing them to a higher level command or the IG, public law states that no person may restrict a military member from making a lawful communication to an IG or member of Congress. In addition to having the right to present personal complaints, a member has a responsibility to report FWA or gross mismanagement, a violation of law, policy, procedures, instructions, or regulations, an injustice, any abuse of authority, inappropriate conduct, or misconduct through appropriate supervisory channels or the IG. Note: only the IG may investigate allegations of reprisal and restriction under the Military Whistleblowers Protection Act. Complaints addressed by other grievance or appeal channels. Matters normally addressed through other established grievance or appeal channels may be referred back to the appropriate grievance or appeal channel unless there is evidence these channels mishandled the matter or process. Complainants must provide some relevant evidence that the process was mishandled or handled prejudiciously before an IG channel will process a complaint of mishandling. Dissatisfaction or disagreement with the outcome or findings of an alternate grievance or appeal process is not a sufficient basis to warrant an IG investigation. For additional information on procedures for filing an IG complaint and further details regarding the program, refer to AFI 90301, Inspector General Complaints Resolution. 1910. Commander's Authority and Responsibility. While preserving an airman's right of expression to the maximum extent possible, Air Force commanders have the inherent authority and responsibility to take action to ensure the mission is performed. This authority and responsibility includes placing lawful restrictions on engaging in dissident and protest activities, writing, distributing, publishing, or posting any unauthorized material, frequenting establishments that have been designated as off-limits, participating in any activities of illegal discrimination or any activities that a commander finds to be detrimental to good order, discipline, or mission accomplishment, interfering with the USAF mission or law and order, or presenting a clear danger to loyalty, discipline, or morale of other members of the U.S. Armed Forces. 1911. Public Statements. According to AFI 1.1, the issuance of public statements on official USAF matters is the responsibility of cognizant unit or installation commanders and their public affairs representatives. Ensuring that official statements are properly worded and approved avoids statements that do not reflect official USAF policy or that could be misleading to the public if taken out of context. To ensure USAF official information is presented professionally, personnel should make certain it is accurate, prompt, and factual, is confined to their particular areas of expertise, avoids a hypothetical and speculative nature, accurately reflects USAF policy, is presented simply and honestly, and complies with the spirit and letter of the Secretary of Defense's Principles for Public Information. For additional information, refer to AFI 35101. As representatives of the service in both official and unofficial contact with the public, members have many opportunities to contribute to positive public opinion towards the USAF. Each USAF member is responsible for obtaining the necessary review and clearance, starting with public affairs, before releasing any proposed statement, text, or imagery to the public. This includes digital products being loaded on an unrestricted website. Members must ensure the information revealed, whether official or unofficial, is appropriate for release according to classification requirements in DoD Manual 520001, Version 1, AFMAN 16-1404, Version 1. 1912. Free exercise of religion and religious accommodation. Every airman has the right to individual expressions of sincerely held beliefs, to include conscious, moral principles, or religious beliefs, unless those expressions would have an adverse impact on military readiness, unit cohesion, good order, discipline, health and safety, or mission accomplishment. According to AFI 1.1, leaders at all levels must balance constitutional protections for their own free exercise of religion, including individual expressions of religious beliefs, and the constitutional prohibition against governmental establishment of religion. They must ensure their words and actions cannot reasonably be construed to be officially endorsing, disapproving, or extending preferential treatment for any faith, belief, or absence of belief. Airmen requesting religious accommodation must continue to comply with directives, instructions, and lawful orders until the request is approved. If the request is not approved, the decision must be based on the facts presented, must directly relate to the compelling government interests of military readiness, unit cohesion, good order, discipline, health, safety, or mission accomplishment, and must be by the least restrictive means necessary to avoid adverse impact. 1913. Political activities. According to AFI 1.1, generally, as an individual, you enjoy the same rights and have the same responsibilities as other citizens. However, as a member of the USAF, the manner in which you exercise your rights is limited in some cases. While on REGAF status, members are prohibited from engaging in certain political activities to maintain good order and discipline and to avoid conflicts of interest and the appearance of improper endorsement in political matters. While USAF members do have the right and duty as American citizens to vote and voice opinions concerning political matters, we must be careful that personal opinions and activities are not directly or by implication represented as those of the USAF. Prohibited activities. USAF members may not participate in partisan political fundraising activities except as permitted in paragraph 2.3 of AFI 51508. Rallies, conventions, including making speeches in the course thereof, management of campaigns, or debates either on one's own behalf or on that of another. This prohibition applies whether the individual is in uniform or not, and regardless of whether an inference or appearance of official sponsorship, approval, or endorsement may be drawn. Participation includes more than mere attendance as a spectator. In addition, USAF members may not use official authority or influence to interfere with an election, to affect its course or outcome, to solicit votes for a particular candidate or issue, or to require or solicit political contributions from others. Military personnel must not actively advocate supremacist, extremist, or criminal gang doctrine, ideology, or causes, including those that advance, encourage, or advocate illegal discrimination based on race, creed, color, sex, religion, ethnicity, or national origin, or those that advance, encourage, or advocate the use of force, violence, or criminal activity or otherwise advance efforts to deprive individuals of their civil rights. Before engaging in any political activities, be sure to review applicable USAF instructions and guidance. AFI 51508 provides detailed information on what USAF members may or may not be allowed to do regarding political activities. DoD Directive 134410, Political Activities by Members of the Armed Forces, 19 February 2008, includes guidance on political activities for all U.S. Armed Forces. Also reference DFIA 52201, Religious Freedom in the Department of the Air Force, 23 June 2021. Note: military members who engage in any of the prohibited activities listed in paragraph and subparagraphs 2.4.1.1 through 1.4.1.19 of AFI 51508 are subject to prosecution under Article 92 UCMJ in addition to any other applicable provisions of the UCMJ or federal law. 1914. Alcohol abuse. USAF policy recognizes that alcohol abuse negatively affects public behavior, duty performance, and physical and mental health. The USAF provides comprehensive clinical assistance to eligible beneficiaries seeking help for an alcohol problem. According to AFI 1.1, USAF policy is to prevent alcohol abuse and alcoholism among its personnel and dependents, to assist USAF personnel in resolving alcohol-related problems, and to ensure humane management and administrative disposition of those who are unable or unwilling to be restored to full, effective functioning. All airmen are responsible for exercising good judgment in the use of alcohol. State and foreign country drinking age laws, including those in deployed environments, must be obeyed both on and off duty. Use of alcohol must not adversely affect duty performance or conduct on or off duty, to include the ability to be recalled, if specifically required, when serving in an on-call status, during scheduled off-duty time. Also reference AFI 34219, Alcoholic Beverage Program, 3 February 2021. Drunk driving. Drunk driving can lead to disciplinary action, including criminal prosecution under the Uniform Code of Military Justice, UCMJ, and local and state laws. AFI 31218, Motor Vehicle Traffic Supervision, 4 October 2016, applies to everyone with military installation driving privileges. A person with a blood alcohol concentration greater than 0.08 is considered per se impaired, even without any other evidence. If a member has a blood alcohol percentage of 0.05 but less than 0.08, the person may be presumed to be impaired. This standard may be considered with other competent evidence in determining whether the person is under the influence of alcohol. There is a 1-year driving privilege suspension for driving or being in physical control of a motor vehicle while under the influence of intoxicating liquor at a blood alcohol concentration of 0.08% or greater. 1915. Substance use or misuse. Department of Defense policy is to prevent and eliminate problematic substance use in the Department of Defense. Substance use and abuse is incompatible with USAF core values, maintenance of high standards of behavior, performance, readiness, and the discipline necessary to accomplish the Air Force mission. Additionally, substance abuse and misuse can cause serious physical and mental problems and jeopardize safety. According to AFI 1.1, the illegal use of drugs or improper use of legal drugs is prohibited and will not be tolerated. In AFI 90-507, Military Drug Demand Reduction Program, 25 May 2017, drug abuse is described as the wrongful use, possession, distribution, or introduction onto a military installation or other property or facility under military supervision of a controlled substance, prescription medication, over-the-counter medication, or intoxicating substance other than alcohol. Wrongful means without legal justification or excuse and includes use contrary to the directions of the manufacturer or prescribing healthcare provider and use of intoxicating substance not intended for human ingestion. Drug abuse also includes inhalant abuse, sometimes referred to as huffing, and steroid use. other than that specifically prescribed by a competent medical authority. Violators are subject to punitive action under the UCMJ as well as adverse administrative actions up to and including administrative separation. The knowing use of any intoxicating substance other than the lawful use of alcohol, tobacco products, or prescription drugs, which is inhaled, injected, consumed, or introduced into the body in any manner to alter mood or function, is prohibited and will not be tolerated. The possession of any intoxicating substance with the intent to use in a manner that would alter mood or function without legal authorization is prohibited and will not be tolerated. Failure by military personnel to comply with these prohibitions may result in prosecution under the UCMJ or state and local laws, as well as adverse administrative actions up to and including administrative separation. Note: USAF members with substance abuse problems are encouraged to seek assistance from the unit commander, first sergeant, substance abuse counselor, or a military medical professional through the Alcohol and Drug Abuse Prevention and Treatment (ADAP) program. ADAP and drug demand reduction programs include substance use and misuse prevention, education, treatment, and urinalysis testing. Members are held to the highest standards of discipline and behavior, both on and off duty. All patients diagnosed with a substance use disorder and entered into ADAP will be recommended for limited duty, indicating the patient is not worldwide qualified. Individuals who experience problems related to substance use and misuse will receive counseling and treatment as needed. However, all USAF members are held accountable for unacceptable behavior. Commander's identification. Unit commanders will refer all service members for assessment when substance use or misuse is suspected to be a contributing factor in any misconduct. Examples include driving under the influence, public intoxication, drunken disorderly conduct, spouse or child abuse and maltreatment, underage drinking, positive drug tests, or when notified by medical personnel. Commanders who fail to comply with this requirement place the member at increased risk for developing severe substance problems and may jeopardize the safety of others and ultimately mission accomplishment. 1916. Drug testing. The USAF conducts drug testing of personnel according to AFI 90-507. Drug testing is an effective deterrent for the illegal use of drugs. Therefore, USAF military members are subject to testing regardless of grade, status, or position. Military members may receive an order or may voluntarily consent to provide urine samples at any time. Military members who fail to comply with an order to provide a urine sample are subject to punitive action under the UCMJ. Note: commander-directed testing should only be used as a last resort because the results may not be used for disciplinary action under the UCMJ or to characterize an administrative discharge. Inspection under Military Rule of Evidence 313. In general, an inspection is an examination conducted as an incident of command, the primary purpose of which is to determine and ensure the security, military fitness, or good order and discipline of a unit, organization, or installation. Inspections may utilize any reasonable natural or technological aid and may be conducted with or without notice to those inspected. The positive result of a urine sample may be used to refer a member for a substance use evaluation as evidence to support disciplinary action under the UCMJ or administrative discharge action, and as a consideration on the issue of characterization of discharge in administrative discharges. Probable cause search under Military Rule of Evidence 315. A probable cause search requires a search and seizure authorization from the appropriate commander, military judge, or military magistrate in order to seize a urine sample. Probable cause exists when there is a reasonable belief that the evidence of illegal drug use will be found in the system of the member to be tested. Results may be used as evidence to support disciplinary action under the UCMJ or in an administrative discharge action. Medical purposes. Results of any examination conducted for a valid medical purpose, including emergency medical treatment, periodic physical examination, and other such examinations necessary for diagnostic or treatment purposes, may be used to identify drug abusers. Results may be used as evidence to support disciplinary action under the UCMJ or in an administrative discharge action. Self-identification. USAF members not currently under investigation or pending action with alcohol problems, substance use problems, or personal drug use or possession are encouraged to seek assistance from the unit commander, first sergeant, substance use counselor, or a military medical professional. Following an assessment, the ADAP program manager will consult with the treatment team and determine an appropriate clinical course of action. Commanders may not use voluntary self-identification of a substance use problem against a member in an action under the UCMJ or when determining the appropriate characterization of service in the administrative discharge action.